Thank you for visiting my channel. Before we start, please hit the subscribe, share, and like buttons to receive notification of future presentations. Our topic for discussion is impossible crime under Article 4, Paragraph 2 of the Revised Penal Code. Article 4. Criminal liability. Criminal liability shall be incurred, 2. By any person performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. Let's break down paragraph 2. An impossible crime is an act which would be an offense against person or property, were it not for the 1. Inherent impossibility of its accomplishment, or 2. On account of the employment of inadequate or ineffectual means. Here are the requisites or elements of an impossible crime. 1. The act done would be an offense against person or property. 2. It was done with evil intent. 3. Its accomplishment is inherently impossible or the means used is either inadequate or ineffectual. And 4. It should not violate another provision of the Revised Penal Code. There are generally two types of impossibility, the factual impossibility and the legal impossibility. But first, let us discuss factual impossibility. Factual impossibility occurs when the intended criminal act is factually impossible to accomplish, even though the person believes they can achieve it. Factual impossibility occurs when extraneous circumstances unknown to the actor or beyond his control prevent the consummation of the intended crime. One example is the man who puts his hand in the coat pocket of another with the intention to steal the latter's wallet and finds the pocket empty. Factual impossibility of the commission of the crime is not a defense. If the crime could have been committed had the circumstances been as the defendant believed them to be, it is no defense that in reality the crime was impossible of commission. The other type of impossibility is legal impossibility. Legal impossibility occurs when the intended act is not prohibited by law even though the person believes it to be illegal. In such cases, the person may have the intent to commit a crime, but the law does not criminalize the specific conduct or circumstances. For instance, if someone attempts to possess a substance that they believe to be an illegal drug, but it is later revealed to be a harmless substance, their attempt to commit drug possession would be considered legally impossible. As there was no illegal substance involved, they cannot be held criminally liable for drug possession. Legal impossibility occurs when the intended acts, even if completed, would not amount to a crime. It would apply to those circumstances where, number 1, the motive, desire, and expectation is to perform an act in violation of the law. Number 2, there is intention to perform the physical act. Number 3, there is a performance of the intended physical act. And number 4, the consequence resulting from the intended act does not amount to a crime. Legal impossibility is a defense which can be invoked to avoid criminal liability for an attempt. The impossibility of killing a person who is already dead falls under this category. In other words, the offender did not commit any particular crime. Objectively, there is no crime committed, but subjectively, the offender is a criminal. In the eyes of the law, he is criminally liable. What is being punished is the criminal tendency of the offender. Impossible crime is a crime of last resort. If the acts of the offender constitute a distinct felony, an impossible crime is not committed. In such a situation, a crime is committed. Thus, if the offender administered adequate quantity of poison in order to kill the victim, but the latter survived because he was immediately brought to the hospital, the offender is guilty of frustrated murder and not of impossible crime. Under Article 59 of the Revised Penal Code, the penalty for impossible crime is arresto mayor or a fine ranging from 200 to 500 pesos. It is important to note that the recognition and treatment of impossible crimes can vary between jurisdictions. Some legal systems may not recognize it as a defense or may have specific requirements for it to be applicable. In our jurisdiction, however, impossible crimes are recognized. The impossibility of accomplishing the criminal intent is not merely a defense, but an act penalized by itself. Furthermore, the phrase inherent impossibility that is found in Article 4, Paragraph 2 of the Revised Penal Code makes no distinction between factual or physical impossibility and legal impossibility. We now come to the case of Intod versus CA, GR number 103119, October 21, 1992. It is from this case that much of the foregoing discussion is lifted. Facts of the case. The 5 accused, all armed, among them Sulpicio Intod, went to the house of the intended victim, Bernardina Palangpangan, and fired specifically at the room of the latter. It turned out, however, that the target victim was in another city and his home was then occupied by his son-in-law and his family. No one was in the room when the accused fired the shots. No one was hit by the gunfire. After trial, the regional trial court convicted Intod of attempted murder, which conviction was subsequently affirmed by the Court of Appeals. Hence, the instant petition for review. The issue is whether the act intended by the offender is impossible of accomplishment and therefore absolved him of a crime of attempted murder as earlier decided by the lower court and affirmed by the CA. Discussion. When the accused shot the place where he thought his intended victim would be, although in reality the latter was not present at said place, there is factual impossibility of the commission of the crime. Under Article 4, Paragraph 2 of the Revised Penal Code, the act performed by the offender cannot produce an offense against person or property because, number 1, the commission is inherently impossible, and number 2, the means employed are either inadequate or ineffectual. The focus of the case is on number 1. Under this clause, there may be either legal or factual impossibility. Legal impossibility would apply to those circumstances where, number 1, the motive, desire, and expectation is to perform an act in violation of the law. Number 2, there is intention to perform the physical act. Number 3, there is a performance of the intended physical act. And number 4, the consequences resulting from the intended act does not amount to a crime. The impossibility of killing a person already dead falls under this category. Factual impossibility applies when an extraneous circumstance unknown to the actor or beyond his control prevents consummation. The case at bar belongs to this category. Petitioner shoots the place where he thought his intended victim would be, although in reality, the victim was not present in said place and thus, the petitioner failed to accomplish his end. The factual situation in the case at bar present a physical impossibility which rendered the intended crime impossible of accomplishment. And under Article 4, Paragraph 2 of the Revised Penal Code, such is sufficient to make the act an impossible crime. So the dispositive portion of the decision goes, wherefore, premises considered, the petition is hereby granted. We hereby hold petitioner guilty of an impossible crime. If you find this presentation helpful, please hit the subscribe, share, and like buttons to receive notification of future presentations. Thank you.